Good evening, everyone. The September 12th, 2023 Liquor Board hearing is now in session. Mr. Praley, if you would, sir.
Yes, thank you, Mr. Chairman. We're back in a virtual land, as everybody can see, so I'll keep this brief tonight. At the beginning of every one of these meetings, I make a few brief announcements. The first is that the commissioners before you tonight are all part-time public servants. Each and every one of them has outside interests. When they know they have a conflict of interest or the appearance of a conflict, they'll recuse themselves. However, due to members of the public being able to testify, not necessarily in the virtual setting, but otherwise, they wouldn't know potentially who could appear on behalf of any applicant or licensee at any given moment. So when your case is called, if you think that any of the commissioners has a conflict of interest or the appearance of a conflict, you need to make that known so that the board can make a decision at that point. Otherwise, we'll proceed forward under the assumption that there are no conflicts or perceived conflicts. Second, the rules of this board provide for the purposes of administrative and judicial economy that the board's counsel can rule on objections and the admissibility of evidence. The chairman has designated that authority to me. So in the event that counsel are present and an objection is made, or there's an objection over a piece of evidence and the admissibility thereof, other than the chairman turning to me advising the chairman, I'll simply make a ruling, and that ruling will stand as the ruling of the chairman and the board. And last but not least, we are doing this via Zoom tonight, as everybody's aware. Because of that, the board's special rules, which are found online, are adopted for tonight's hearing. Pursuant to those rules, anybody who wishes to be heard at the hearing who is not a participant in a specific proceeding, they must submit written testimony to be considered and provided as part of the official record 5 days prior to the hearing date. So any submitted writings are automatically accepted as an evidence, as a piece of evidence or exhibit in an applicable case. Other than that, the public is certainly welcome to watch tonight's proceedings. They're not allowed to participate other than by providing that written testimony, which should have been provided prior to the hearing. Those are all the announcements tonight. So with that, I will turn it over to Deputy Chief Inspector Sean Ralston, who can call the first case. Just to let everybody know also that because this is a virtual hearing, there will be no waiver of the reading. So Deputy Chief Inspector Ralston, please.
Thank you. Our first case is a continuation from the June 27th, 2023 hearing. It is Gateway Village Wine and Spirits, Gateway Village Wine and Spirits LLC, Raghu Kumar, managing member. The inspector is Jure Slocum. This is for a new license at 2645-A Housley Road, Annapolis, Maryland, 21401. It's a Class A beer, wine, liquor, and Sunday license.
Okay, and before we get started on this one, as Deputy Chief Inspector Ralston indicated, this is a continuation. Public testimony has been closed. The record has been closed. The sole purpose of tonight's hearing is to place the board's decision on the record. And keep in mind that a written decision will be forthcoming probably first thing tomorrow when the administration can circulate that via email. Hard copies will follow via regular mail. Mr. Chairman.
Okay, thank you, Deputy Chief Ralston and Mr. Praley. With that being said, I'm going to go ahead and start with a motion. My motion in this case is that we accept the applicant for the license, and I'm going to ask for a second.
This is Commissioner Duffy. I'll second the motion.
Thank you, Commissioner Duffy. All those in favor signify by saying aye, please.
Aye.
Aye.
And aye here. With that being said, the motion to accept the license is granted, and the license will be issued. Thank you.
Look for the written decision to be coming with statements, with findings of fact from the board in the next day or so.
Thank you, Mr. Praley. Deputy Chief Ralston, you can call the next case.
Our next case is Sidelines Sports Bar and Grill LLC, Daniel Ipes Jr., authorized member, Rebecca Paxton, authorized person, Billy Ipes, manager, Claudia O'Keefe, inspections and permits, This is Inspector Scott Harmon and Chief Inspector Jim Ford. Violation one is violation of the rules and regulations of the Board and License Commissioners for Anne Arundel County, Chapter 3, Section 3.02, Cooperation regarding Board of License Commissioners for Anne Arundel County, violation notice number 2286 by Chief Inspector Jim Ford, dated July 12th, 2023. The second violation is a violation of the rules and regulations of the Board of License Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct regarding Board of License Commissioners for Anne Arundel County, violation notice number 2286 by Chief Inspector Jim Ford, dated July 12th, 2023. The third violation is a violation of the rules and regulations of the Board and License Commissioners for Anne Arundel County, Chapter 4, Section 4.18, alterations regarding Board of License Commissioners for Anne Arundel County, violation notice number 2286 by Chief Inspector Jim Ford, dated July 12th, 2023. This is a Class H beer, wine, liquor, dancing, and Sunday license at 105 Chesapeake Center Court, Arnold, Maryland, 21060. It has a restriction dated February 11th, 2014. The dancing license must be granted annually by the board at the time of renewal. The dancing license will not automatically transfer with the license, but must be approved by the board at the time of transfer. Anyone wishing to testify for or against, please stand and raise your right hand.
If I could just interrupt for a minute.
Sure.
One of the licensees, Daniel Ipes, I'm not seeing him. He did register. There are a couple of users that just are called Zoom users. So if one is Daniel Ipes, if you could just identify yourself, raise your hand so I can pull you into the room. I don't see Billy Ipes either. They did register, but I'm only showing one licensee, Miss Paxson. So nobody is raising their hands.
Miss Paxton, are you there? Can you hear us?
Yes, I can hear you. I mean, I know that they're on audio. I just don't know. I'm gonna see if they can hear you.
I have two phone numbers. Last four digits is 6766 and 6985.
6985 is Danny Ipes, yes.
Okay, I will promote. I will allow to talk.
Okay.
And how about Billy, Miss Paxton?
She is supposedly on as well. That might be the other phone number then, ending.
666.
No,
I'm
it'd be
sorry?
60
There's one ending in 6766 that I see.
That might not be them. I think they're on the same line because they're together.
Okay.
She's just asking why you guys can't hear them.
If this is the number 6985, I'm asking them to unmute. So that's something they have to do on their end.
Okay.
Okay,
Hello?
And
have them?
Yes.
Okay.
he's there.
Can you hear me now?
Are both of the licensees on the same call?
Yes, we are.
Okay, Mr. Fraley, we're
Can
okay.
you, Mr. Ipes, can you turn your camera on your device, or are you at a place where you can't do it?
How do I turn it on?
There should be a little camera that you push. It's like
We're on the audio call, so how do I do that?
Oh, is it, if it's just audio, I don't know if you can.
Yeah, I don't believe you can. They called in using telephone number, so I don't know if there's an option for video. It's not looking like on my end. It doesn't show that there's an option for video.
All right, that's fine. Miss Paxton, can you turn your video on?
I don't think I have a camera on my computer at home. I
Okay.
don't have a camera on my computer.
Okay.
I had to
All right.
leave my office in order to be able to get home to make this call. So yeah.
Okay, understood. Mr. Chairman, I would advise that we can proceed forward and having him sworn in. While video would be helpful, it's not necessarily required.
Okay, thank you, Mr. Praley. Mr. and Mrs. Ipes, you do understand, even though we can't see you, that when we hear you speak, if you would, please identify yourself before you say what you want to say, just so we know for the record who's saying what. Okay?
Yes, Daniel Ives, I understand. Thank you.
Okay.
Yeah,
Thank
this is Billy.
All right. Thank you. All right. Mr. Praley?
Mr. Olson, can you swear everybody in?
Correct, yes. For, I think, Rebecca, Claudia, Daniel, Billy, Jim, and Scott, do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
I do.
I do.
This is Billy. I do.
Daniel Ives, I do.
Rebecca Paxton, I do.
Okay, so if you could please state your name and address for the record. We'll start with Chief Inspector.
Chief Inspector Ford, Anne Arundel County Liquor Board.
Scott Harmon.
Scott Harmon, Anne Arundel County Liquor Board.
Daniel Ives.
Daniel Ives, 1605 Braid Hills Drive.
Rebecca Paxton.
Rebecca Paxton, 6992 Deep Cup.
Billy Ives.
Billy Ike, 1605 Braid Hills Drive, Pasadena.
Claudia O'Keefe.
Claudia O'Keefe, Inspections and Permits, Anne Arundel County.
All right, thank you, Mr. Praley.
All right, thank you, Mr. Olson. I appreciate it. The way that we're going to do this, I know Ms. O'Keefe is going to want to testify as well, potentially Mr. Harmon, but we'll start off with Chief Inspector Jim Ford, who can provide us with a statement of facts. After that, just for Ms. Paxton's edification and Mr. and Ms. Ipes, after Mr. Ford gives his statement of facts, we're also going to hear from Ms. O'Keefe, and we're going to hear from Mr. Harmon if they have anything to add. At that point, it'll be your opportunity to question them. Now, these are just questions that you may have based on their recitation of the of the facts of the case. After that's happened, the board will have the opportunity, and including the chairman, to ask any questions that the commissioners or the chairman may have. After that's done, you'll have your opportunity to present your case. So just recall that you're only going to be asking questions after Chief Inspector Ford, Ms. O'Keefe, and Mr. Harmon provide their statement of facts. I just want to make sure that we lay the groundwork there for everybody so this moves smoothly. With that, we'll let Chief Inspector Jim Ford provide the statement of facts. Mr. Ford, please.
Thank you, Mr. Praley. This is from a report incident description. The activity date is July 12th, 2023. The report date was July 12th, 2023. At 12:30 p.m. on the date listed above, which was July 12th, I entered the facility and delivered notice of violation to manager on duty, JB. JB called and put me on the phone with Billy Ipes, who protested the violation. I explained to Mrs. Ipes that the licensee would have an opportunity to present licensee's arguments before the board at the violation hearing. The following violations were issued under violation notice number 2286, 3.02 cooperation, specifically in connection with failure to cooperate with the removal of an unapproved outdoor alteration by January 10th, 2023, as directed in writing by then Chief Wayne Harris on behalf of the Board of License Commissioners, dated November 29th, 2022. 4.16, illegal conduct. Licensee has allowed the commission on licensee's premises of acts against the rules and regulations of the Board of License Commissioners. 4.18, alterations. Licensee has made material alterations to the premises without the approval of the Board of License Commissioners. I've written up a timeline beginning with February 6, 2022. Licensee was warned, and you can see this in an attached report amongst the materials, that the board had concerns about the placement of an outdoor alteration in the form of a permanent fence, some tables and chairs. The concerns were that the alterations may not be allowed by inspections and permits. April 11th, 2022. Licensee was warned a second time about the board's concerns regarding the unapproved alterations. April 20th, 2022. Licensee's request for the outdoor service in a letter dated April 20th, 2022, subsequently denied by the board. August 31st, 2022, Liquor Board Inspector Scott Harmon performed an annual inspection at Sidelines and provided the manager on duty with a third warning That report is also attached regarding the unapproved outdoor service area. November 29th, 2022. Then Chief Wayne Harris had a conversation with manager Billy Ipes, explaining the board's reasoning for the denial of both the alteration to the premises and the outdoor service request, which included information stating that then Chief Harris had consulted with Claudia O'Keefe, engineering manager, inspections and permits for Anne Arundel County, whose department had rejected the permit. That same day, then Chief Harris followed up via email and required the removal of the outdoor alterations by midnight of January 10th, 2023. January 10th, 2023, to the day the violation was issued, the outdoor alterations remain. And a verbal addendum to this, I was by there this past Saturday evening, and it is still there. This concludes the report.
All right. Thank you, Chief Inspector Ford. Inspector Harmon, is there anything that you want to add to the statement of facts?
Not at this time.
Thank you. Ms. O'Keefe, anything that you would like to add as well?
I would just add that they applied for a building permit to install a fence on the outside of the building. They applied, I believe, December 27, 2022. The permit was not approved. There were outstanding comments. They applied for a second permit on January 19, 2023. This one was for outdoor seating, and that permit was also not approved. Comments were outstanding, and there was no revision submitted for either permit. Both permits are still pending, not approved.
Thank you. At this point, we'll turn it over to the board to see if they have any questions. Mr. Chairman, any questions of either Chief Inspector Ford, Ms. O'Keefe, or Mr. Harmon?
No, I have no questions at this time for any of them. Thank you.
Commissioner Snoops or Commissioner Duffy, any questions?
I have no questions.
This is Commissioner Duffy. I have no questions.
Okay. All right, well, we'll turn it over to the licensees then to see if the licensees have any questions of either Chief Inspector Ford, Ms. O'Keefe, or Mr. Harmon. Any questions?
This is Billy. I do not have questions. However, I would just like to state that my understanding was that if we had an open permit, that we did not have.
Ms. Ipes, this is just your opportunity to ask questions. I don't mean to jump on you there, but we need to keep it clear here. Just your opportunity to ask questions of the report. If no questions, we'll turn it over to you to present your case in mitigation.
Okay, no questions.
Mr. Ipes, do you have any questions?
This is Daniel Ipes. I have no questions. Thank you.
Ms. Paxton, do you have any questions?
Not at this time.
Okay, great. Then we'll turn it over to you all to present your case in mitigation. Ms. Ipes, you can continue on. Sorry for jumping on you there. We just want to make sure that we do this in a logical order so people aren't talking over each other. So go ahead and say what you want to say, and then we'll see if the board has any questions, okay?
Yes, understood. So this is Billy Ipes again. And whenever we were approached by a couple different members of the liquor board, it was my understanding that if we had an open permit, that we did not have to take the fence down just yet. Backstory for those that don't know, the fence was built during COVID when we were almost encouraged to do so, to have outdoor dining. When we were informed we were no longer permitted to serve food and alcohol on the patio, we did not do so. We placed signs stating no food and no beverages outside. So we did not serve food and alcohol. So basically the structure was just there from, like I said, built around sometime in 2020. And then it was our understanding we applied actually in November of 22 for the first permit. It ended up being the wrong type of permit. And then you have the dates we applied in December and January. And again, each time more information was requested, I provided what was requested. The last thing I provided was something to the health department and did not hear anything. And then the last email that I have not approved, subject to lots of different requests. I just did not have everything together, and that was in June of 2023. So we were verbally instructed by several members of the board that if we had the permit processing, we didn't have to remove the structure just yet. And we weren't serving, again, we were not serving food or alcohol on the patio. And, you know, we have every intention and always have. We have, 15 years of nothing but compliance with the local board for 2 different restaurants and bars. And this is our first violation. And I did not think we were under violation if we still had the permit in process.
All right, thank you, Ms. Ipes. Mr. Ipes, Ms. Paxton, anything that you would like to add?
Daniel Ipes, no, not this time. That was time to accurate.
Rebecca Paxton, not at this time.
Okay, all right. Mr. Chairman, any questions?
I do. I'd like to first address Chief Board. Do you know of any time where you may have spoken to Mrs. Ipes and informed her that she could utilize that facility under the condition she's stating?
No, sir. And I would also like to hear from other inspectors about that as well. And if I could, also Claudia, with respect to the handicap parking.
Yeah.
So the answer is no.
Okay, thank you. And I'm going to get to both of those issues next. Inspector Harmon, did you at any time inform Mrs. Ipes or Mr. Ipes, or for that matter, any manager on duty, that they could use the facilities as long as there was an application in progress for a building permit?
I did not.
Okay, thank you. Mrs. Ipes, do you remember who you heard from who informed you that it was okay to do that?
So Wayne, when you were still chief, you and I had a conversation, and you instructed me that as long as we filed for the permit prior to January, it was sometime in the fall, and the permit was in process because it takes some time, then we wouldn't have to take it down immediately. And then we had a new inspector briefly. I apologize, I do not recall his name. Saw him twice maybe, and he checked in, and I said the permit is in process, and he was like, okay, just keep us updated. And that was it. And I just want to state again, we were not utilizing the space for food and alcohol service. It was just the structure, of the fence was there.
Okay, thank you very much, Mrs. Ives. My next question, I'm going to address Ms. O'Keefe. Ms. O'Keefe, did you have a conversation with Mrs. Ipes in reference to the application or the process, or was it just a letter giving her an update, or could you give us some information as to what was addressed?
Okay, for the first permit that they submitted, I produced a comment letter dated January 19, 2023, that explained what additional information was required for the permit. They should have received an email from Inspections and Permits sent on January 23 of 2023 with my comments and also the comments from Planning and Zoning. When they submitted their second permit, They submitted the second permit on January 19, 2023. Additional information was requested on January 20. Additional information was provided on June 9th, 2023. My review letter is dated. My review letter for the second permit is dated June 2023. Let me see, June 13, 2023. And they would have received their comment letter from that on, or they would have received an email that there were comments outstanding on June 23 of 2023. So for the second permit, they were asked for additional comments on January 20th, and they didn't produce any information until June 9th. And by then they had my first comment letter that asked about handicap parking and fire lanes and fixture layout on the floor plan, and none of those comments were addressed in the second permit.
Okay, thank you very much. Mrs. Ipes, I know in reference to what Mrs. O'Keefe is talking about, you at one time had 2 handicap locations directly in the front of the building, and I understand that one of those was either painted over or an adjustment made or something like that without permission of inspections and permits? Or did you talk to somebody in inspections and permits about doing that?
So during COVID, again, we were allowed to put up a permanent patio, which we did move the handicap space to the side of the building, and it was marked and accessible. But we were, just verbally told it was COVID and we could do that. So that was done, like I said, in 2020, not recently. And now after the fact, it's an issue. And I guess my biggest question now is just, is there a chance of changing the zoning, or is that completely out of the question? And then, of course, by the time I received her comments from June, again, so I didn't receive an email, and I finally had to call in order to figure out how to access this information on the website. And by the time I accessed it, it was end of June, and then we were already end of June, early July, and then we were told about this hearing. So since it's saying it's not approved again, and we were told about this hearing anyways, I haven't responded to inspections and permits for the last comment.
Okay.
Regarding the comments or questions they're asking, for things they're asking for. Some of the things it looks like I believe I've already provided some of them. Maybe they just weren't detailed enough. Yeah, I don't know. At this point, I mean, what do you want me to do? I mean, I think that it's sounding like we would have to apply for zoning changes and involve the landlord in that.
Okay, I think that can be addressed shortly, but I want to make sure that the other 2 commissioners have an opportunity to ask questions from anybody who's testified or needs to, and then we can address that and tell you, or at least give you some idea of where you must go to get your answers in order to proceed or whatever. But for now, what I'd like to do is ask Commissioner Duffy and Commissioner Snoops if they have any questions for any of you. Commissioner Duffy?
No, this is Commissioner Duffy. I have no questions of anyone.
Okay, Commissioner Snoops?
I have no other questions now.
Okay, thank you. Thank you both. I think that's all the questions. Well, now that I think about it, let me ask you this. So the handicap spots that are underneath of the outdoor service area that is still there and still fenced in, they have not been put back into its original location. You moved them to a location you felt was adequate. Whether that's true or not, or good enough or not, is not for me to answer, but inspections and permits or zoning. I guess my question is anybody at all going outside, going out that door and into that outside service area that has the tables and chairs for any reason, whether it be smoking, eating, drinking? And I do remember you saying nobody's been out there to eat and drink. But has anybody gone into that outdoor service area?
There are customers that use the space for smoking, yes.
Okay, thank you. Well, that's all I
And
have.
this is Daniel.
Yes, sir.
This is Daniel. Yeah, our whole original intent, of course, we want to comply with the liquor board, and we've always wanted to comply and do whatever is necessary. And that was the whole purpose of the fence in the first place, was to keep the, during COVID, to keep everybody contained and we had a temporary tent put up for 6 months to a year in that same location. And then we were advised that we were putting up a permanent one would be better to keep everything contained in there too. So we always want to comply and do everything we can. Like I said, it was my understanding last time I spoke to Mr. Harris that we had to file a permit, and he actually informed us we had to file a permit. I wasn't aware of that at the time because it was during COVID. And we applied for the permit, and he actually informed me about the handicap spots. And I looked up and said we had two. We had two originally in the front. We still have one in the front, and he advised me to move one to the other spot, and I moved one to the other spot. So we would try to do everything we can to comply. And Billy was doing the whole entire process and submitting the application for the permit. Like I said, she just recently came back with more information that was stuff that she couldn't produce by herself. So she was actually hire a company to do all the layout and the measurements and everything else at the time. So as far as we know, that we were just still waiting on the permits to go through, and we were advised that as long as the permits were being processed, it was a problem.
Okay, thank you, Mr. Ipes, and Mrs. Ipes as well. I have no further questions at this time for anybody.
All right. If there are no further questions, Ms. Ipes, Mr. Ipes, or Ms. Paxton, is there anything you'd like to add?
This is Daniel Ipes. Not this time. I'm Billy.
No from Billy.
No for Rebecca.
All right. Nothing else to add. No additional questions. We'll turn it over to the board, Mr. Chairman.
Thank you, Mr. Fraley. Mr. and Mrs. Ipes, first of all, let me give you a compliment as to the design and the structure of the outdoor service. It's probably one of the finer ones that I've seen, using the powder coated aluminum fencing and gates and so forth. But at the same time, I don't believe you followed the requirements that Anne Arundel County requires. And I know Mrs. Ipes, there was a comment about not needing a permit to put up the fence, but it's my understanding, and I think Mrs. O'Keefe can confirm that you do need a permit for that. And a lot of things go into getting a permit other than just saying, yes, you can build a fence, whether it's aluminum or wood or whatever. Location, and your location was on a parking lot. So you replaced your outdoor service over top of parking spaces, including one handicap. You reduced the stripe zone between the two handicaps. And then I'm not quite sure who told you could do it, but then you moved one of the handicap spots around the corner of your building. I don't believe we have any evidence that you were told that by any official with Anne Arundel County inspections and permits or zoning or anything. So I guess really what I'm getting at here is even though you did make an attempt, from the time this all started to the present, you weren't able to accomplish getting a permit. I don't know how successful you'll be in the future. That's not for us to decide. But I think what I'm going to do is I'm going to make a motion now that you be, well, before I make that motion, let me just say these three charges, they're not earth-shattering in their severity for non-compliance, but yet they are important because failure to follow the rules, the regulations, the advice from the liquor board in an official capacity, I think is something you as a licensee has to take seriously. You were also told and informed, according to the reports, to cease and desist use, and that was all use. That wasn't an exception for smoking. You I think, have been given plenty of time to reach out and follow up with inspections and permits in order to get the permit or see what had to be done to get the permit. Well, I'm going to make a motion that you be found guilty on all three charges. I'm going to recommend a fine of $100 per charge. So you have three charges, a total of $300 plus the administrative cost, which is like a court cost. And I'm also going to direct that fenced-in area be locked. And this might be a problem with fire marshal, so I'm going to need to make sure the fire marshal inspections and permits, because there is an ingress-egress door going into that area. But we need to see that area, unless you get a permit immediately, cease and desist all use, and that it be removed and taken down and put back into its original condition. And of course, if you can get an exception, or if you can get a letter from inspections and permits, zoning, or any of the proper authorities, otherwise we would be willing to look at that and accept it. So that's my motion: $100 per charge plus administrative costs, and in order to remove that outdoor service area immediately, putting the handicap space back where it was initially. And I'm going to ask for a second.
This is Commissioner Duffy. I second the motion.
Thank you, Commissioner Duffy. With that being said, all in favor?
Aye.
Aye. And that'd be it. Mr. and Mrs. Life, I wish you a lot of luck in this endeavor, but it's really important that you do this immediately. Thank you.
Thank you. We will, absolutely.
Thank you. Okay, Deputy Chief Ralston, call the next case, please.
Our next case is Fish Paws Marketplace in Delhi. Divisi Incorporated, Kimberly Lawson, President, Inspector Christine Cerrone, Inspector Mary Deschamps, Chief Inspector Jim Ford. It's a Class D beer, wine, liquor, growler, and Sunday license at 954 Ritchie Highway, Arnold, Maryland, 21012, with no restrictions. The violations are as follows. Violation 1 is violation of the rules and regulations of the Board of Licensed Commissioners for Anne Arundel County, Chapter 4, Section 4.16, illegal conduct regarding the Board of Licensed Commissioners for Anne Arundel County, violation notice number 1702 by Chief Inspector Jim Ford, dated August 7th, 2023. The second violation is a violation of alcoholic beverages and cannabis Part 2, Titles 9-35, Annotated Code of Maryland, Title 11, Section 11-1103.1, non-refillable container permit draft beer, regarding Board of License Commissioners for Anne Arundel County, violation notice number 1702 by Chief Inspector Jim Ford, dated August 4th, 2023. Anyone wishing to testify, please turn on your cameras and raise your right hand. Do you solemnly swear and affirm under the penalty of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay, so please state your name and address for the record, and we will start with Chief Inspector Jim Ford.
Chief Inspector Jim Ford, Anne Arundel County Liquor Board.
Eddie,
Yeah, Edward Aronson, Administrator, Board of License Commissioners, 2011 D Commerce Park Drive, Annapolis, Maryland, 21401.
Inspector Cerrone,
Christine Cerrone, Anne Arundel County Liquor Board.
Kimberly Lawson,
Muted.
Kimberly Lawson, Device Incorporated, 5 Beechwood Road, Arnold.
I think that was everybody. Anyone else?
I think that's everybody, and I'd ask Mr. Brown and Mr. Lyman to put their appearances on the record if they wouldn't mind.
Good evening, Samuel J. Brown, BROWN.
And Brian Lyman, LYMAN.
Both on behalf of the licensee.
All right, nice to see you both tonight. We have a lot of people who I think are going to want to testify on this one. So we're going to start off with Chief Inspector Ford providing us with a statement of facts. Then we're going to turn to Inspector Cerrone to provide us her statement of facts. Then Mr. Brown, Mr. Lyman, we'll turn it over obviously to you all to ask questions of the Chief Inspector and Inspector Cerrone. We'll allow the board to ask questions. And then we'll see if Mr. Aronson wants to testify. We'll go through that same song and dance. All right.
Mr. Praley, before you start that, I'd like a motion to dismiss if I could.
Sure, go right ahead.
Thank you. On behalf of the licensee in this case, I'd ask that the board dismiss the charges against them. If you look at your own file and your records, you'll find that this right to growlers existed as of July 1, 2017. In April of 2017, which will show as Exhibit 1 on there, which we sent to the board, Kim Lawson sent a letter to the board advising that she wanted to have a crawler's license and the information. She sent a copy of the actual bill that went in, and the bill, as you'll note, states the following things. It says down at the end, an applicant who has a refillable container permit may not be charged a fee for a non-refillable container permit. It also says that that the board may issue a non-refillable permit license upon the following terms and conditions. But paragraph D says the board shall adopt regulations to carry out this section. If there are regulations involved, we have never seen them. And I've looked through your booklet and I don't find any regulations at all regarding crowlers or growlers that I've been able to find. If I've missed them, Mr. Preley, I know you'll point it out to me and tell me where they are. But we know of no regulations at all. And as a result of that, the board has no regulations, unless you can show us that there are some. What happened after the April 11th, 2017 note from Ms. Lawson is that the board then communicated with her. And you have our Exhibit B, which we sent in, which are communications between Ms. Lawson and others at the board, where she sends in the actual application, okay? She sends in her affidavit and information. She sends in copies of her labeling, and the application itself shows it's a non-refillable container permit. That was filed on April the 23rd, 2018. So on April the 23rd, 2018, the new license had not been issued yet. According to information from one of the representatives of the liquor board, there's a $200 fee to change a license. Well, there's not permitted to be any fees under the code section, specifically because it says, as I read earlier, that an applicant who has a refillable container permit may not be charged a fee for a non-refillable container permit. Now, the argument I know from the board is that, well, we have to reissue a license so we can charge a fee. The problem is, this was April the 23rd, 2018, when she issued it. The board was issuing a new license by May 1 that year, which would have meant the board did not have to make any changes to its license itself. And therefore, there should not be a $200 fee because she paid her renewal fees, and she's paid them every year since then. Based on that going on, the board, I think at that time, had an obligation to issue the Crowler license to her for the May 1, 2018 renewal, the May 1, 2019, 20, 21, 22, and 23 renewal. So every year the board has had an obligation because they can't charge a fee And it didn't mean that the board had to change anything because the fee had been paid, the application was in, the labels were approved, and everything was ready to go. In addition to that, the board members have walked through this place on many occasions. 2 years ago, a board member walked through as inspector and checked the place out, saw that they were selling crowlers, never said a word, no one has said a word to them. Now, like the last case you just had a minute ago, the county sent notices of violation to the individuals, telling them they were in violation. What you all did was a sting, which makes no sense to me at all. It's almost like you're trying to find these people in violation and cause them problems and cause an issue for them, which makes no sense to me at all based on this board. I've been trying cases before these boards for 46 years. My first case was in front of Reese King. I've been trying cases before the city of Annapolis for 46 years when the city council acted as the liquor board. And I've never seen a situation where the board goes out and tries to find people in violation and or creates the violation. In this case, on April the 4th, April the 2nd, I think it was, I'm sorry. Let me get the exact date on the inspection thing. It was on August 2nd, I'm sorry. August 2nd, someone goes in and buys alcohol, buys a crowler. They don't issue a citation at that time. They knew the crowlers were there. Fish Paws has been selling it, and we'll admit that we've been selling this since 2018 because they thought they had the license in 2018. Nobody knows that you have to put in CG, CG, CR, GR on the license in order to show it because you don't have any regulations on this. So what happened is they've been selling it, but you send somebody in there to violate them, to prove that there's a violation. This isn't like a selling under alcohol, underage or anything. It's out there. They're advertising they're selling it. The world knows they're selling it. And it's been going on for, like I said, for this 5-year period of time. But then you don't issue a citation on that day. 2 days later, someone comes back, and that time the chief inspector comes back and issues a citation. I don't understand this. I don't understand what the intended purpose is because it makes no sense that the board is out to try and create violations when this board, like the county did in the violation with the other person, sent him a letter and said, you are in violation, you got to move this fence or you got to get a permit. If somebody would have notified Miss Lawson that there was a problem, that she needed a permit, that application would have been in immediately and she wouldn't have sold until it's done. As it is now, the application is in. It's in there sitting there waiting for you all to approve it, just as she thought it was in on April the 23rd, 2018. Now, I don't know where this $200 fee comes from, and I don't know what's going on. I don't know why this is happening, but I don't think this is a violation because you've let it go on for 5 years. 5 years you've condoned the fact that she is selling crowlers out there when your inspectors were in there on a regular basis, when the chief inspector came in and walked the place with Miss Lawson a year to 2 years ago when they were talking about carry out delivery alcohol and things of that nature, and the crowlers have been sitting there ever since. And so I'm not sure how this can be a violation when, number one, you don't have rules and regulations unless you can tell me what they are because I can't find them anywhere and I don't know that they've ever been advertised. Number two, that the board had an obligation in April of 2018 to issue this license to her for crowlers as well as the growlers. It had the same obligation in 19, 20, 21, 22, and 23. So I'm confused as to whether what's going on now and why it's happening. And Mr. Prelli, if you have information on the rules and regulations that under the code section, and specifically code section, as you read it down there, you see where it is. It's under on the page 3 of the Exhibit 1, which is the April 11, 2017 letter, where it says the board shall adopt regulations to carry out this section. And you know, when you adopt regulations, you're supposed to notify the world of what those regulations are so we're not in violation. You can't have ex post facto laws, and meaning you create something and then create a violation for someone. So I would ask this board to consider everything that's happened. Consider the fact that the board for 5 years could have issued this, never did. She was unaware that it was. She didn't know what the procedure was except to do whatever she did. She didn't pay the $200 because it didn't need to be paid because you had a license that did not need to be changed. New license didn't be issued. When you issued the new license in every one of those years, you could have included it on there at that point. And I think that $200 fee is in violation of the code section passed by the state of Maryland anyway. So I'd ask you to consider dismissal of this immediately without her having to go through anything else. And I presented our case, even if we get to that point, basically by giving you all my facts, as Mr. Predley's smiling because he knows I present my case completely when I can. But I don't understand how a board that's here to help us, and I've heard members of this board say for years, we're here to help you. We're not here to hurt you. We're here to work with you. This was not a working with her at all. This was out there to sting her and to prove some type of point. And I don't know what this point is. And I'd like to know what that point is. And I'd like to know why these charges are even existing against DeVries, Fishpaws, Miss Lawson. That would be my argument, Mr. Praley, Mr. Chairman, and other people. And so I'm not sure where we go from here, how the board wants to handle it or reject it, or show me where I'm wrong, where there's actually rules and regulations that cover this thing, which I haven't seen.
Now, I appreciate the argument, Mr. Brown. I'm actually trying to figure out if there's a way that I can, it's difficult for me to give legal advice to the board members when we're kind of live streaming this right now. So I'm trying to figure out if we can go off the record so I can chat with the chairman and the commissioners for a minute.
I just Googled that and I did not find a quick enough answer.
Okay.
I'm not sure that we can just pause. I'm gonna see if there's a thing called breakout room.
I don't know if that'll be live streamed.
Yeah, I'm not sure because this is being live streamed.
Right. Mr. Preley, one other thing that I would make a comment on, if the board wants to talk when it's off the record, whatever it's doing, or you walk out to the other room or do something. Mr. Chairman, you were the person who came in 1 year to 2 years ago and walked the place with Kim. Therefore, you probably knew or should have known at that time that it was there. And I'm not sure that based upon the fact that you have facts relevant to the case from before, that you can act sitting on this thing. So I'd ask you to recuse yourself.
Understood. Understood. Thank you for bringing that to our attention as well, Mr. Brown. Eddie, is there any way to?
You can move us out somehow, maybe. I don't know. Can you move us and put us all in a private room except for you all, or put all of you into a private room?
You can mute Jimmy.
I think the problem that we're having is that it's being, if you look in the bottom, at least for my screen, it's the bottom right-hand corner, it says Arundel TV, and that's
Right.
actually live streaming this. So I think even if we kick you all out and we have a private room, it's still going to be live streamed.
Could you not turn off your microphones and conference each other in and just turn around?
Telephone call.
That's an idea.
All right. So do you want me to call your office, Eddie, and we can patch everybody through, or how do you want to do it?
Sure. So if everybody will mute themselves, turn off their video until we get a chance to do the discussion.
All right. Thanks. Sorry for the delay here, guys.
You're going to call us?
Bernie, I'm planning on calling Eddie's office and we'll figure out a way to conference everybody in.